Right. And Newsfile is brought to you by the candid sponsorship of Bank of Africa, strong as a group and close as a partner, MTN everywhere you go. Ashasi University, educating ethical and entrepreneurial leaders for Africa. Robert & Sons Optical Services, your comprehensive eye care service provider for 33 years plus. My Way Insurance, dial star 165 hash to on MTN to join today. DPS International, where every child shines. Flamingo Paint, simply superior. Syntex Tanks, it's strong, it's tough. Activa International Insurance, our clients are passion. And my outfit, as always, is by Konati Clothing. You can find them at Adenta Shopping Center, Adenta Down. You call 0244 6767 32, 67 67 32. Konati Clothing, what you wear counts. And between now and the Christmas, they are doing a special discounts for those of you who will patronize them. They are offering between 10 to 15% discount between now and Christmas. So place a call to Konati Clothing. Now, let me welcome my other guests. But it's been brought to my attention that the fake news thing is really heavy and is going on. The cybersecurity, the national security, they must do something about it. The one I showed Evans and asked about, which he issued a disclaimer that their campaign is unaware about. There is another one also the same way for John Mahama's campaign as well. And they are saying you should fund the campaign, and then they give you a link, you click onto the link, then they ask you whether what you saw earlier. So these are scammers that are harvesting people's data. And they have done that for both the Mahama campaign and also the Baumia campaign. There is a group, particularly the Media Foundation for West Africa, getting other peoples together, and they have formed a coalition of fact checkers Ghana to make sure that they will be able to help counter these things because they will endanger the elections. Right. So in the studio is Gary Nimakumafu. He is Director, Legal Affairs of the NPP. Joining us via Zoom, Inusa Fuseni is lawyer, former MP, Tamale Central, and former Minister, Lands and Natural Resources, Roads and Highways. We also have Professor N.S. Kofi Abochi, Dean, UPSA Law School, and privilege to be joined also by Justice William Atuguba, retired Supreme Court judge. So let's begin on this note. As I read to you, Gary, the Supreme Court, by the 5-2 majority on jurisdiction, and then 5 on the substantive matter, because the two, once they decided that the court doesn't have power to determine the case, but it should go to high court, they didn't go into the substance of the matter itself. Let's begin this way, not from the top, but from the substance. They made a permutation. Mm-hmm. Justice Asaridako, who wrote the lead judgment, made a permutation at the end to give us what it means for an MP to lose their seats. And he said, I read that again. It says, in the end, we reiterate that on a true and proper interpretation, Article 97(1)(g) only requires that an MP must vacate their seat if, so note the incident, if they leave the party under which they were elected to join another party or become independent and seek to remain in parliament under their new political status. If you are an independent MP, then Article 97(1)(h) requires that you vacate your seat if you join a political party in Parliament and you seek to remain in Parliament under your new political status. He didn't end there, and he said, a purposive interpretation of Article 97(1)(g) and (h) of the Constitution confirms that their focus, as in the framers of the Constitution, their focus is on safeguarding the electoral mandate during the current parliamentary term and not on restricting MPs' political activities in the next electoral cycle. Historical examples, contextual interpretation, and the inclusion of Article 97(2) all point to the same conclusion. MPs' current parliamentary affiliation remains intact until they actively change their political allegiance during their term, not when they express future political intentions. Yep.
Samson, good morning to you. Good morning to your distinguished panelists so assembled this morning. Let me say that I agree in its entirety the decision of the majority on this subject matter. You recall that I was on your studio some few weeks to express similar position.
2 weeks ago.
2 weeks ago. That until the MP has physically moved in Parliament to change the character of his political lineage or situation, you cannot say that 97(g) and (h) has been triggered. I made this point here. Because you see, Samson, let's understand this point. Parliament is elected for a term specific. 4 years, 4 years. Not more than that. Since 1993 up to now, so this is the 8th Parliament for a term specific.
They stated that. They stressed it.
Good. Now, everything that happens in Parliament for an MP to change his character must happen necessarily in Parliament. What does it mean to say that the MP has changed his character whilst in Parliament, Samson? The MP came to Parliament as a member of a political party.
Let's take Formina.
Formina came to Parliament as an independent member of Parliament, though earlier on he was a member of the New Patriotic Party.
Yeah, and he
won independent.
Yeah.
Now, whilst in Parliament, as we speak, the MP says, in future, the 9th Parliament, I want to contest as a member on a ticket of the New Patriotic Party.
Which he has filed his nomination.
Now, Samson, in Parliament, the sitting arrangement is only two. Either you're on the left aisle or you're on the right aisle. Majority, minority. There's no middle ground. Now, if you come as an independent member of Parliament, you must decide whether to go and sit with the majority side or the minority side. As we speak, Esiama he came to Parliament on the majority side. Sorry, sitting with the majority side, and he's not sitting with the majority side. And I made a point here that unless Esiama moves to the minority side, you cannot say that he has crossed carpet. In the same vein, these two MPP members of Parliament, that is, remember the name, the other one.
Cynthia Morrison.
Cynthia Morrison, and then the other one.
Is it called Kojo?
Kojo Asante, isn't it? Good. Yeah. They came to Parliament in the name of the party. As we speak today, they have not moved their position from the MPP side to the side of the NDC. So how don't you say that they've crossed carpet whilst in Parliament? The NDC member of Parliament, as we speak, still remains with the side in Parliament. So everything that we are talking about here, the Constitution makes it very clear. It means that it must happen in the life of the Parliament in Parliament, not outside Parliament. So when somebody plays a certain meaning, and by the Speaker of Parliament, that to my understanding, the filing of your nomination as independent member of Parliament or the thing of a political party amounts to cross-carpeting, that you have left the party that brought you in the parliament, and so therefore, to my understanding,
let's
you have
be
vacated
careful.
your seat.
Let's be careful what the speaker did not say. So let's not project what he did not say.
Oh, you can.
He gave the definitions of what cross-carpeting is.
Yes.
And
the record is before you, and I have it here as well. So in case maybe I'm veering off.
If you're referring to a record, be specific about it.
Mm-hmm. All I'm saying is that the Speaker of Parliament, Right Honourable Abang Kingsford Sumana Bagbin, placed a certain meaning on Article 97 G and H. And for him, his view was that the mere filing of nomination with the EC amounted to a vacation of the seat of these members of Parliament. That was his understanding. And then the majority side also placed a different meaning. That no, it doesn't apply. Because this is all futuristic, not what? Current. At that stage, something, the issue of interpretation arose. It arose. And so therefore, to my mind,
at which stage did the issue of interpretation arise?
At the stage where the Speaker of Parliament placed rival meanings to the provision of the Constitution. Because his understanding of the provision and that of the other side clearly were at par. They were at par. And so therefore, to my mind, I thought that the Speaker, at the time when the writ was even filed, with an injunction added to it, he will have just stayed his hands. Look, I have made this point very clear.
You just said something, and it's instructive.
Yes.
You said the time when the controversy, so to speak, arose was when the Speaker gave the announcement in Parliament.
He gave a ruling. He says that announcement is
I'm using his words.
Okay.
Okay.
I remember he said that
he actually said he gave information.
Adjourning to give a reasoned decision on the matter.
Now wait. The standing orders of Parliament on which he relied said he's supposed to give information to the House.
Right.
So he gave what he calls information. We know the effect of it.
Yes.
The court simply says that the effect is a ruling. Now, this decision at the very onset says the suit was filed 2 days before that decision.
That is correct.
So do you see that there's a problem in law as about the course of action accruing?
You see, the Supreme Court made it very clear here, and at the very beginning of the decision, that, and you see, I made this point the last time, the Speaker has hastened slowly. Maybe it will be where we are now. The Supreme Court made it very clear. They said that if the issue was just about future happenings, they would not have been able to intervene. And for the fact that the Speaker of Parliament now made a decision, a ruling, which had the effect of entering the Constitution, that's why the adjudication was now what? Invoked. So you see, for me...
So you agree?
Yes.
That at the time that Afenyomakin went to court,
yes,
the course of action had not yet accrued.
Well, I agree with you.
You agree on that?
I agree with you.
Okay.
I agree with you.
In law...
That is why... Hold on.
In law and in your practice, does it happen that a course of action has not accrued and a court will entertain you when you go before them?
Well, but when you file a process in court, you have just filed it. Nothing has happened. What happened in this case was when the orders were given, which had the effect of changing the character in Parliament, that application for stay was brought.
You're moving ahead.
I'm not moving ahead.
Yeah.
I'm not moving ahead. I'm saying that, you see, assuming the Speaker of Parliament, at the time the writ was filed with injunction attached to it, he has said, well, for me, I stay in my hands. I'm not going to move. Go let the Supreme Court decide. If the Supreme Court decides, then I will now come in and be abided by what the Supreme Court says. I'm saying we'll not be where we are now. The point I'm making is very simple. To me, I think that at the time when the court made the stay application, or better still, at the time when the Speaker made the ruling, the plaintiff ought to have taken steps to amend the writ, okay? Amend the writ. If you look at the release carefully, you realize that some of the releases were made redundant because of the way they were couched. amend the rate, ask for specific reliefs, which will bind the speaker's hands when one way or the other. But by and large, if you read the entire judgment, it is very clear that the court...
So stay there briefly for me. In your practice, in the very normal scheme of things, when you go to court, the standard, we know that there must be predictability. Otherwise, the judicial system doesn't exist. There must be certainty. So, first, if you had a client and somebody approaches your client with a writ together with an application for stay of, an application for injunction.
For injunction, yes.
An application, not that it has been determined. The same way happening in this case. And they are serving it on your client. Let's say they've even served it on your client about something your client has not done yet. What would be your advice to your client?
Yeah, my advice to the client is that, you see, because the injunction application is seeking to tell you that don't do X, please don't proceed to go and do the X, because the substance of the application is saying that please don't proceed. So don't proceed. Because you see, if you proceed, and the very thing that the court is being sought for, to injunct you, you go ahead and go and do it.
Wouldn't you tell your client first? Wouldn't you tell your client first that since you have not done the thing, there's nothing to be injuncted about?
Oh no.
That the person who has brought the suit actually doesn't have a case because you haven't done it.
You see, one thing that I'm very careful about, I'm saying, is to try to be in contempt of court, or try to advise the client in a manner that the client will be in contempt of court. Look, you know orders of court, and you are aware. Even if they are made, whether they are rightful or they are wrongful orders, you are supposed to obey those orders. So my humble view is that once you file a suit and attach injunction to it, and you serve the client, I have to file my hypothesis to respond to it. Let the court decide one way or the other how it should go. I would never advise the client that proceed to go and do the very thing that the plaintiff is seeking, that stop, don't do it. No, I will never do that.
Right.
I would never do that, and I've never done that. So
let's go to the substance, back to the substance.
Yes. So, as I was saying, if you look carefully at the 97 1 G and H, which really, you rightly pointed out that you have to make sure that the person at the time of cross-capping or whatever it is has happened in Parliament. Some have suggested that, should have gone to the High Court. High Court had jurisdiction in the declaration of a vacant seat. I agree. But you see, the plaintiff was not in court to declare a seat vacant. He was in court for interpretation of Article 97 1 G and H. That's the crux of the matter. And I read the minority position on the matter. They were so silent on whether or not an interpretation arose or did not arise. They didn't touch about it. All that they were saying is that, well, the forum was to have been a High Court, so you have go to the High Court. But you see, you're going to the High Court for what? For declaration of a vacant seat or for an interpretation of 97? If it was the interpretation of 97, then obviously the Supreme Court was seized the jurisdiction to interpret the matter as far as the part that placed rival meanings to the provisions of the Constitution. It was so clear.
Is 99 really about declaration?
99 1. Today you have felt me, you borrowing me with your Constitution. Now 99 1. So the High Court shall have jurisdiction to hear and determine any question whether A, and I think let me go to where, yes, A person has been validly elected as a member of Parliament, or the seat of member has become vacant. That's what the High Court will do.
To determine a question.
A question.
That is a controversy.
Yes.
That is a dispute.
Yes.
Whether a seat has become vacant.
Has become vacant.
You are saying this is not what this suit was about?
No. This was about interpretation of 97. That's why you should distinguish it.
The interpretation was to say that a seat has become vacant or a seat has not become vacant. Is that not it?
The interpretation was, the resultant effect of the interpretation of 97 will let you see that by your conduct, by what you have done, you have declared a seat vacant, which you ought not to have done in the first place.
Right. So there's a question.
Are you getting my point?
So there's a question, there's a dispute
Yes.
about whether, in fact, those seats have become vacant. Not correct. Is that not it?
No, what the Speaker did in Parliament
Yes.
was by interpreting 97 G and H, and the effect was to declare a seat what? Vacant.
Correct.
These are two things that happen.
And somebody is not happy.
Yes.
That this situation cannot lead to the seats becoming vacant.
Exactly.
So the question to answer, or the controversy, was whether the seats of these 4 individuals had become vacant or not.
No. The question to determine was whether interpretation placed by the Speaker on 97 G and H.
I know what you're doing.
No.
Okay.
You see, something. You need to let the people understand. The interpretation of what the Speaker has done has led to a resultant figure where now a seat has been declared vacant. So, let's go to Abrewa, at the Supreme Court.
What is the bottom line? What's the bottom line of the end game of the majority decision? What's the end game of the majority decision? If it is any different from what I read to begin with.
The end game, to my understanding, is that the majority have now placed an interpretation to 97, and they made a declaration to that effect.
So the end game is that the end game is that the 4 MPs, their seats cannot be vacant by virtue of what they have done.
Yes.
How different is that, the end game here, from 99 saying that if there is a question, there's a controversy, or there's a contest about whether a seat has become vacant, the place to go is the High Court.
You see something. Let's understand this way. The Speaker of Parliament did an interpretation. What he calls applying the Constitution was an interpretation. It's his understanding.
And everybody is entitled to do so.
No.
Once they apply the Constitution, they're entitled.
If you are applying it, then yes, you can apply the Constitution.
You interpret before you apply.
You see, but when you say it is clear, how did you write that it is clear? You see, the Speaker of Parliament placed a meaning on 97. He interpreted the meaning of 97, which is the exclusive president of the Supreme Court.
When there is
rival meanings being placed on the provision.
Correct. That does not mean the government institutions and all of us, we don't interpret this Constitution and apply it every day. That we are not entitled. If we have any issue, if we want to use the Constitution, we should go to the Supreme Court before we use it. That's not what you are saying. Just education for the public.
Yes, you know, unless there's a controversy on a matter, the course you don't go to the court.
Right.
If, for instance, you take a provision of the Constitution or any act of Parliament and you apply it, and there's no controversy, you go on. You are free to go on. But when there's a controversy, the parties to the issue are fighting over the matter.
All right.
And placing rival meanings to a provision in the Constitution or a statute or an act of Parliament. You cannot sit there and say, look, we want to proceed and do it. So for me...
So it doesn't matter that you go to court even before that happens. You go to the court and say, the Speaker is saying something different. And I am also saying something different about this provision.
Yes.
And you go 2 days before the Speaker says that.
You see,
it doesn't matter.
There are different ways of going to the court. And let me put this way. If a provision in the Constitution is not clear, it's unambiguous, you can go to the Supreme Court, and that's 130 for interpretation and enforcement.
You know, if it is, not if it is not.
No, if it is ambiguous.
Correct. You said unambiguous. That's why I was seeking to correct you.
Sorry. If it is ambiguous, it admits double meaning. And the parties are putting rival meanings to it. You can go to the Supreme Court.
Right.
At that one, you realize that it is not about you are going there because people are fighting.
Okay. Because
parties themselves disagree with the
Why did you say a while ago that the plaintiff, Afenyo Marking, should have amended his rate after the development actually happened?
Yeah, because you see, if you look at the reliefs that was being sought, specifically reliefs 2, 3, I mean, even at 4 by 4 is just the usual this thing. But especially 2 and 3, you see that these matters were overtaken by events. The fact that you want injunction against the speaker from not putting any interpretation on 97, he has already done it. He's done it already. So it has been rendered superfluous, rendered odious here. And then the fact that there should be an injunction barring the speaker from enforcing 97, 1G and H, already he's done it. So, tactically and procedurally, this rate ought to have been amended to get specific reliefs.
What's the effect of not amending it?
That is why the Supreme Court could not give any consequential orders. That is why. Because the court cannot grant what you have not asked for. You see, you go to court either as a plaintiff with a writ and your reliefs all listed in there, a defendant with a counterclaim. If there's no counterclaim, you can't say that the court will grant the counterclaim. All right? The counterclaim is a fresh writ or a claim. All right. So, if you go to court and at the end of the day, the court says that you are proving your case. So, all the relief that you are asking for, I've granted you some. Or the relief you are asking for, I will not grant it. But what you have not asked for, the court cannot grant you.
Do you share the views that this judgment practically is empty?
It is not
Kwame
empty.
Akufu,
it is not empty.
Kwame Akufu, Kweku Ansah-Sareh,
it is not empty.
Thaddeus Osoreh,
it is not
among
empty.
others, say that
I disagree with them.
This judgment does not have teeth.
You see,
it has no grip because there are no orders.
Samson, I made a point just a while ago.
I want you to do this quick so I'll go to the other part.
Just a while ago, whilst the court could not have given orders or could not have made orders that were not asked for. Okay? If you read the judgment in its entirety, you will realize that the Supreme Court implicitly in the judgment has said that the interpretation the speaker put on 97G and H was wrongful.
That's plain.
What's wrongful?
That's plain, yeah.
If something is wrongful, what do you do? The thing is wrongful. What you said it is, it doesn't mean that it is. So that these 4 MPs can just walk to Parliament when the Parliament is recalled and go and take their seats. You can't stop them from entering Parliament. So how do they, the judgment is implicitly in the judgment, it is clear.
Is the speaker supposed to do something since there's no order against him? Is Parliament supposed to do something since there's no order against him?
You should recall Parliament and let the MPs enter Parliament. They come and do their work. That is all.
Okay.
You should recall Parliament. These MPs can't be stopped from entering Parliament.
The final point on this. I've been trying to illustrate to people who don't have an appreciation of the law, who don't have a training of the law. And I say, when you file a writ, for example, and you say that somebody has trespassed on your land, and you ask the court to declare that that person is a trespasser, they'll declare so, right?
Yes.
If you don't ask the court to make an order for that person to vacate the land and give you vacant possession.
Recover possession.
Yes, to recover possession.
Yes.
What effect
the court you cannot recover possession. You can't recover possession. Once the court they don't make a decree for the recovery possession, you can't recover possession.
So you know that in Accra and elsewhere, there are many people who have gotten land litigation victories. They got a declaration that, yeah, this land is yours. They didn't get any more. The persons they won the case against are still on the land.
Yes, I agree with you. If the court does not decree for recovery of possession, or you don't plead it in your relief, the court cannot grant you. I've had a situation whereby a case I was doing, the lawyer had judgment, and then there was no relief as to recovery of possession. And after the judgment was delivered, they now try to do the enforcement by now entering recovery of possession. I want to set aside the process. And the court agreed with me because once you don't ask for recovery of possession, you cannot get a decree for recovery of possession. But this particular instance, it's a different thing altogether. It's a constitutional interpretation the Supreme Court did. That's why you see the Supreme Court, look at the relief. The Supreme Court essentially granted relief 1,
A, B, and C.
Yes.
So, yeah.
Yes, which was declaratory in nature, which they came and they were asking for, and the court granted the relief for them.
Thank you. Let me go to Let me go to Inusa before Professor Abochi and then Justice Atuguba. So let's go to Abochi. No, I wanted us to talk to Inusa before Abochi. But I understand that Abochi will have to leave us. So let's go to Abochi now. Professor Abochi, thanks for joining us. Hello, Prof.
Thank you, Samson.
Great. Good to hear you. I'm very good, sir. Thanks for asking. So the majority decision in the conclusion said that we reject the invitation to reinterpret or effectively rewrite these constitutional provisions to imply that an incumbent member of parliament shall not file nomination to contest on a platform different from the one on which he was elected unless he first vacates his current seat. Such a reading imposes an undue restriction on political freedom, a constraint not articulated in the original text of the articles. The constitutional language should be construed holistically and purposively, without imposing limitations that could curtail the fundamental freedoms of sitting MPs and ultimately sabotage the rights of the electorate. Isn't this a fair reading and interpretation of the provisions, that their declarations and their filing to contest is for the future? It does not affect the current parliament. And they continue to do business. They have not changed their character by which they entered this parliament. So they should not be punished for it.
I have subscribed to the future or the futuristic aspect of the provision as the court concluded. So the court's position is one that I've subscribed to, and I've actually said this on your network in the past before the judgment came out. So I'm very much of the view that the decision really should be about the present and not the future. However, the reason the court ascribed to it, with the greatest of respect to the courts, is extremely problematic. Now, the reason it's problematic is precisely the reason of political freedom is what the Constitution seeks to constrain. The Constitution, in essence, is saying that if you go to Parliament on one promise, you do not have the pleasure, you do not have the freedom to change willy-nilly as and when you wish. In other words, while all of us can change our political alignments, members of Parliament can only change their political alignment on the pain of losing their seats and having to go back. And so for the court to therefore rationalize this on grounds of political freedom and the right of choice of a member of Parliament is to undo precisely what the Constitution seeks to prevent, i.e. the fact that you can stay out of Parliament and change your party anytime you want. That's your business and that's your prerogative. But if you're in Parliament, the promise on the basis of which you went to Parliament, you cannot change anyhow. And that is partly the difficulty, again, I have with another aspect of the decision, which I have to say, by the way, the judgment is nicely and lucidly written. I enjoyed reading it in terms of the lucidity of the articulation. But there are a few problems with the judgment. Another problem.
The one you just mentioned, let's stay there for a minute. It says MP's current parliamentary affiliation remains intact until they actively change their political allegiance during their term, not when they express future political intentions. You say this is a wrong statement of the law?
No, that's what I've said. I've said I actually subscribe to the futuristic aspect of the change. In other words, the fact that the change must be to your current membership of Parliament, not your future.
Okay, so Esiama,
I subscribe to that theory. The point I'm making is the rationalization of that I found problematic with respect. And the reason I found problematic is what I've already articulated. The fact that basing it on the freedom of choice is in my opinion, and with the greatest respect to the court, not an accurate statement of the law in this case, because the freedom of choice of an MP is constrained. The MP doesn't have the same flexibility and latitude that we have to make choices of our political alignment. MPs don't have that. MPs must stick with the parties with which they went to Parliament for purposes of doing business in Parliament. And that's what I was going to state about the other difficulty that I have.
So you are saying that if you are changing, you are in the known that you are sacrificing those freedoms. Is that what you are saying?
That's what it is.
Okay.
In other words, the Constitution doesn't allow the changes in the exercise of the political freedom of choice. The Constitution doesn't allow that for MPs for purposes of being in Parliament. And that's what I was still going to,
Still stay there. Stay there briefly for me. Stay there.
That difficulty.
Stay there for a second.
Difficulty. Because it's important to understand that for purposes of this something, otherwise this one is not complete. It's a point I'm making is connected.
All right.
I'm saying the other difficulty.
No, hold on. Let's just clear this before you move there. When the judgment says that MP's current parliamentary affiliation remains intact until they actively change their political allegiance during their term, not when they express future political intentions. My question is, Andrew Esiama, for example, he is independent doing business with the NPP. Now, he has filed on the ticket of the NPP. He must be a member of the NPP before he can file on the ticket of the NPP. Has he changed political allegiance or he has not?
Well, that's the point I was going to make. And that's why I said it's a complete set of analysis. So I'll be grateful if you can allow on this. So the point I was going to make, therefore, is that as I read the judgment, I realized that the court did not speak in the positive term. The court spoke in the negative term. Now, in the negative term, in the sense that the court actually told us what does not constitute vacation of seat. What I did not see in the judgment is the positive statement of the circumstances that constitutes the vacation of seats. I think the positive statement would have been very helpful. And that's the question you're asking, which is what I've been trying to say all along.
Is this not the positive statement?
Imperative.
Is this not the positive statement when they say an MP must vacate their seat if they leave the party under which they were elected to join another party or become independent and seek to remain in Parliament under their new political status?
Correct. That's positive. But the question is, what constitutes the leaving the political party? That is a broader statement. In fact, if you look at the contestation in Parliament, it seems that the proposers are saying that they have left the party. The opposers are saying they haven't left the party for purposes of the current Parliament. And so it would have been helpful to understand what constitutes leaving a party. Now, I can hazard some guesses, and I have to be clear. I'm not a court, so I'm just speculating at this stage. But we can hazard some guesses. For example, who does the Member of Parliament do business with? Where does it sit? How is his name captured in the Hansard? How does the Clerk of Parliament capture him in the various parliamentary transactions, records, and administrative processes? How is he even captured by the Speaker when the Speaker when he's trying to catch the eye of the Speaker? Generally, what characterization and what association does he bring to bear in terms of he being in Parliament? In other words, the constitutive element of leaving the party is a factual statement, and that factual statement is made up of elements that I would have been grateful or happier if the court had actually itemized those. I think as we stand at the moment, we have still not resolved that big fundamental question. And for the future, this thing will arise again. What has just happened represents a precedent that I'm sure other parties replicate. The next time another party is in majority and the other is in opposition, and we have a situation of independent candidature declared, we are going to have this possible scenario again. And therefore, it should have an imperative that we have a definition, a detailed definition of the constitutive element of what represents leaving the party. Because that's the expression that the Constitution uses. So the Constitution itself,
what represents leaving the party? Can we take solace in what the parties say is leaving the party when they submit their constitutions? And the court took time to speak about the fact that the Constitution requires these parties to submit their constitutions, and their constitutions must conform to the Constitution of Ghana. When the NPP's constitution says that any member who makes a declaration or who is found to be doing things contrary to the party's candidature or the party's candidate in a particular constituency, that person automatically, those are the words of the Constitution, automatically forfeit his membership. Do we understand leaving a party, what it means? Does that help?
So when we say you have left something, let's come back to basic English. When we say you've left something, it represents a voluntary departure. It's on the face of it. It's on the face of it easy to understand that you have voluntarily departed or moved away or left something. We can easily also understand that forfeiture represents not voluntary, but it represents a self-deprivation. You haven't done something and deprived yourself, therefore, of another thing. And so if you do something you're not allowed to do, and by reason of that you forfeit, the understanding of supposition is that, again, you've lost it. So we can also add that to leaving. But what about when you are, for example, dismissed? When you haven't forfeited, you may not have done anything wrong. You may not have done something that constitutes forfeiture, but you've been dismissed for whatever disciplinary purpose or whatever the reason is, you've been dismissed. Would that constitute leaving? An interpretation may probably say, yes, the effect is the same.
The Parliament Act says so, that if a member is dismissed or expelled by their party, they will lose their seat.
Correct. So the point I'm making, as we have the situation before the Supreme Court, and as the Supreme Court is trying to do a full spectrum analysis of the elements that constitute leaving, so that we don't have any controversy as to whether or not this person is still a member of a particular party. That's the point I was making about, I would have been happier to have seen a more positive statement of the circumstances that constitutes vacation of seats. Remember, leaving is just one, but the whole gamut of things that constitutes vacation of seats. Because I really do expect that this matter will arise again. And in the circumstances of the judgment, I think we have only partially addressed it.
How will it arise again? The Supreme Court does not interpret a provision twice.
No, I'm saying it could arise again if you have a situation in which, for more complex reasons, you have a speaker of parliament saying that in light of his own interpretation of the Constitution, somebody has left. Because the Supreme Court has still not defined the positive aspects of leaving, the positive aspects of vacancy. What it has mainly done is to tell us what it doesn't agree with as constitutive of vacancy in the current circumstances of the facts. I think the court was a bit limited by the current circumstances. It tried addressing the current circumstances in the context of the factual scenario. But the situation could arise again. And you can mark the space. The situation will arise again. And in the context of the court's decision, I don't think we have the tools enough to deal with the other circumstances that could arise over and above the current circumstances.
But you, Professor Bochi, in principle, share the outcome to the extent that what happened, what the 4 MPs have done, should not amount to they losing their seats, correct?
It will be, I would not say I share the outcome. I think it's a bit more problematized. I would like to state that. First of all, as to whether or not this matter should have ended up in court in the first place is something that I have great doubts about. I think we are over-judicializing our politics. And it's something
Prof, before that, help me with this. The conduct of the 4 MPs, should it result in they losing their seat from where you sit? Yes or no?
If you take, again, my position on it being a futuristic thing, I would typically say that for the declared intent, that of itself should not have amounted to they losing their seats. Now,
so
it's
that,
again a bit more complicated.
So that it is your expectation that the majority leader, Afenyo Marking, today can declare that he wants to contest on the ticket of the MPP, of the NDC, or as an independent, and then he files his nomination. He should still stay in Parliament and finish his business because what he's doing is for the future, correct?
No. On that basis, beyond the future, it's a bit more complicated. The point I'm making is if he files his nomination, how do you file your nomination of a political party if you are not a member of that party? Virtually all the parties in Ghana have membership as a requirement. So if you file and if you have filed and you have been announced on the electoral register, it means that you have become a member of that party. So in terms of the factual circumstances, you would have left the party on the basis of which you're elected. So I'm just saying that these things, look, the futuristic aspect of it.
If you have left the party in the circumstance you just described, should you lose your seat?
Absolutely, you should.
You should.
Because it's the statement, yes. It's a statement
but the Supreme Court puts a stress.
And in fact, the Supreme Court has
the Supreme Court put a stress on an incident that is a condition precedent, that you must seek to remain in that parliament under your new character. So Afeyomakin files to contest as independent, or he files to contest on the ticket of the NDC, he must seek to remain in parliament under that new character. Otherwise, he doesn't lose his seat. You disagree with that?
No, I don't disagree with that. I actually absolutely agree with that. And that's why I said it is a multi-purpose test. And that's why I would have wished that the court had actually stated this in a corporate global term so that we have a clarity on the matter. You don't just leave a party, so to speak. You have to leave a party within the context of your representation in parliament. Remember, Article 97 is focused on your representation, not your membership or otherwise of a party in the abstract. It is focused on your representation in parliament. So how does your membership of the party affect your representation? And that's why I said earlier that how are you captured, for example, in the Hansard? In the debates, how are you captured? In terms of the speaker, the clerk's administrative incidents, how are you captured? How does the speaker recognize you?
Okay.
There must be a multiplicity of factors in terms of your representation. And I would have wished that, again, the decision stated that in more positive, concrete global terms, so that we have a composite statement of what constitutes you leaving the party, but beyond that, what constitutes vacancy.
Okay, so now help us with this. Let's know where you stand. That Article 2, Clause 2 of the Constitution says that for the purposes of giving effect to the declarations that the Supreme Court makes, let me read it, Article 2, Clause 2. It says the Supreme Court shall, for the purposes of a declaration under Clause 1 of this article, and Clause 1 is when you come to complain that somebody, Clause 1, let's read it. Thank you. Let's read it this way. A person who alleges that an enactment or anything contained in or done under the authority of that or any other enactment or any act or omission of any person is inconsistent with or is in contravention of a provision of this Constitution may bring an action in the Supreme Court for a declaration to that effect. So Afeyomakin went to court for a declaration to the effect that the Speaker has interpreted the Constitution but wrongly. Then 2 says the Supreme Court shall, for the purposes of a declaration under Clause 1, which I just read, of this article, make such orders and give such directions as it may consider appropriate for giving effect or enabling effect to be given to the declaration so made. Do you share the view that in the absence of declarations in the terms of Article 2, Clause 2, this judgment is a Brutum Fulmen? It's an empty judgment. Do you share that view?
Not at all. I don't think it's a Brutum Fulmen. I think it's unusual that the Supreme Court typically would have given a judgment without an order, because the order is perfect and complete judgments. But it's not Brutum Fulmen. If you look at the Constitution under Article 1, Clause 2, it says anything done inconsistent with the Constitution is void. Therefore, where there's a declaration of anything having been done in violation of the Constitution, the declaration essentially is saying that that act is void. So even if it is not capped with a consequential order, under the principle of what we call in constitutional law, nullification impairment, the statement of nullification that makes it void impairs any action against the void conduct. So even without a consequential order, you are not supposed to act pursuant to the void order. So the principle of nullification impairment deals with that. It doesn't have to be capped with an additional order for a particular conduct in one direction or the other.
Right.
The fact that you've been told that you're doing it wrong implies that the act has been nullified and your further conduct in that respect has been impaired.
Is there a problem to the effect that there's no order or direction at the Speaker or the Parliament? The Speaker was the first defendant, though.
Not at all. That's the point I'm making about the nullification impairment. There's no, but it's important to put this in context. I think one thing that lots of people haven't realized, that the Speaker really did not make any orders for purposes of him being injuncted and therefore for purposes of him being given orders. In other words, the Speaker made a declaration of a status quo. What the Speaker did was to declare that seats have become vacant pursuant to Article 97. So he simply declared the status quo per the Constitution. When someone makes such a declaration, you only need a counter declaration to stop that particular declaration. You don't need an order, because to stop the Speaker will be to stop him from doing nothing. He hasn't done anything. He hasn't put armed policemen at the entrance of Parliament, preventing these members of Parliament from taking their seats. He hasn't made an order for their names to be struck from the register, for example, of Parliament, or the Hansard. He hasn't made specific orders of things that should be done, which should have been reversed per order. What the Speaker did was to make a declaration. So the Speaker's conduct was declaratory. Therefore, a counter declaration solves the problem. He doesn't need to be directed to do any specific thing because he hasn't even done anything. And that's why when I hear arguments about contempt, I wonder, what is the Speaker going to be held in contempt of? Because he hasn't really done anything. All he did was to make a declaration of a status quo. It is the members of Parliament, NDC and MPP members of Parliament, who have been squabbling on the question of majority and minority seats and who does what pursuant to the Speaker's declaration. So the Speaker himself did nothing. He only made a declaration which has generated a furore. And so making an order against him rather would be the order Brutum Fulmen, if you ask.
Do you share the view, and this will be my last question to you, that maybe last but one, because we come to jurisdiction, which I want you to be brief about. Do you share the view that this particular statement in the lead judgment is the reason no orders were made, so to speak, and that this is seeking to say that if you want to get orders specific, you should rather go to the High Court? It says that the suit essentially hinges on a pure question of law, specifically the proper construction of Article 97(1) G and H, to establish the legal threshold for triggering its provisions without delving into factual disputes regarding seat vacation in Parliament. Please note that it is to make the interpretive job without delving into the factual disputes regarding seat vacation in Parliament, which properly lies within the High Court's purview under Article 99 of the Constitution. Accordingly, to the extent that the exclusive preserve to settle a matter of interpretation under Article 2(1) and Article 131 and 2 lies with the Supreme Court, it is incumbent on this court to exercise jurisdiction and resolve the interpretation for the application of the High Court. Make note of that. To resolve the interpretation for the application of the High Court. The decision of this court in ex parte Zanato 1 cited supra refers. Let's hear you.
Well, I can't tell whether that's the reason orders were not given, consequential orders were not given. But as I indicated, the lack of consequential orders in this case, frankly, for me, is not fatal. A declaration of unconstitutionality is enough to address the void nature of any order or action, and therefore it addresses that. The question of jurisdiction, however, is more difficult for me to accept, and I would have wished that the court had actually ceded jurisdiction to the higher courts. Now, I'll tell you this is the reason. The Constitution is structured to respond to specific needs, and the clarity of the Constitution in terms of separating things cannot be ignored. The determination of the petition on who the President of Ghana is, presidential petition, is left to the Supreme Court. The determination of the parliamentary election, any petition for parliamentary election, is left to the High Court. What the Constitution framers sought to do was to create a bifurcated arrangement in which the Supreme Court is in charge of things presidentially, and then the High Court is in charge of things parliamentarily, so to speak. This cannot be mistaken. And I think that the reason for that is that the framers intended that the Supreme Court should not be overburdened unnecessarily by the 200 and something people who have been elected. And since we have one High Court scattered across the country, and there are different High Courts closer to different constituencies, let's leave parliamentary business or the decision of who has been elected to Parliament. Let's leave it to the High Court. Now, if you look at the framing of Article 97, which you read earlier, Article 97 contains an implicit interpretation. So even though the Supreme Court has exclusive jurisdiction, under the rules of interpretation, which all lawyers or law students are taught in law school, the principle of the generalia specialibus principle, where you have a specialized provision dedicated to a particular entity, and then there is a derogated general provision, the law says the special provision reigns. So even though Article 130 and Article 1+2 gives the Supreme Court exclusive jurisdiction in constitutional matters, Article 99 specifically vests the High Court with just that small specialized area of dealing with matters concerning Parliament, so that even if they do contain some collateral aspects of interpretation, the Constitution has given that to the High Court. And if you look at the provision, it says the determination of whether there has been a vacancy. There cannot be a determination without implicit interpretive matters that are collateral to that determination process. And those implicit collateral determination matters are not they do not derogate from the overall Supreme Court mandate of exercising authority in terms of the interpretation of the Constitution. So I think that when it came to
Professor Abochi, once again, don't you see that in the portion I have read to you, there appears to be a concession to what you are just saying? They say that this suit essentially hinges on a pure question of law, specifically the proper construction of Article 97, 1G and H, to establish the legal threshold for triggering its provisions without delving into factual disputes regarding seat vacation in Parliament, which properly lies within the High Court's purview under Article 99 of the Constitution. And they proceed to say that they will do this, and they said that it is incumbent on this court to exercise jurisdiction and resolve the interpretation for the application of the High Court. Is that a concession?
Well, I mean, you can give that concession that the Supreme Court is trying to clarify things. The Supreme Court is trying to bring some clarity on how the High Court should exercise its jurisdiction. If that is the intent, which we can glean from the judgment, then it's not a bad intent, to the extent that the High Court will now be better equipped to exercise its Article 99 jurisdiction. I would have rather expected that perhaps the Supreme Court could have assumed jurisdiction in terms of the scope of Article 99 for the High Court to exercise, but that is not the question before it, and therefore it could possibly go into that.
So that this would mean that the Supreme Court is saying, now we have interpreted this provision, so you can always go to the High Court to apply it, and the High Court cannot apply it differently to determine whether there's a vacancy or there's no vacancy. They will be guided by the decision we have made. Is that not what they are saying?
Right, and that's the point I'm making, that with that intent in mind, it's not a bad intent. It's a good intent. It's almost like the court saying, look, we are going the extra mile of clarifying a position. Moving forward, the High Court is equipped. I think the only difficulty, as I indicated earlier, is that even in that, I did not see the full scope of determination of the circumstances of how a vacancy occurs. I think that the court could have probably given us much more indications of the various circumstances. I think it's still a bit too general, and that's why I worry about the future. Thank
you very much, Professor Abochi. And this is where we'll end this discussion with Professor Abochi. We'll take a break. We'll return. Remember, I've got two other guests online, Honorable Nusa Fuseni and Justice William Atuguba. We'll be right back. You're welcome back. This is Newsfile. It's your most authoritative news analysis platform, and here on Newsfile, we put Ghana first. And I trust that you are enjoying the education that you are receiving. And this is the only channel and the only platform that you get this kind of platinum legal education brought down to your appreciation. And my guests, you have heard Professor Kofi Abochi, you have also heard Gary Nimakomafo, and now I'm going to speak to Justice William Atugba, a retired Justice of the Supreme Court of Ghana. Thank you very much for making time to join us, sir. My Lord Justice Atugba, good. Thanks for joining us, sir. Please unmute your mic, sir.
Is it?
Great. I think we can hear you now.
Okay.
Yeah, so, my Lord, having listened and followed everything so far, what do you make of the argument that the majority was bound to decline the jurisdiction or dismiss the suit when they admitted at the very start that the suit predated the complaint breach by the Speaker? Because it was filed 2 days before the Speaker's complaint conduct.
Yes, on that issue, it's right, because, the court has jurisdiction to entertain actions. Now, what is an action? We all know is the allegation and enumeration of those set of facts which, if proven, will entitle somebody to relief. And those set of facts cannot arise in a vacuum. There must be cause and effect. Otherwise, once it's settled that the Supreme Court does not offer advisory opinions, if you come before the course of action has arisen, you are seeking an advisory opinion, but has no jurisdiction. In any case, a party that launches a premature suit has to be thrown out, simply because he has no suit, valid suit, before the court to adjudicate upon. It's as simple as that. But you cannot mount a premature suit and then later try to feed facts which have arisen to show that now the suit has matured. The suit has been filed already. You deal with it as it is filed and as at the time it is filed. That is how jurisdiction is ascertained, not through subsequent events relating to a matter instituted before a court in order to ascertain course of action.
Gary Nimako here says that he believes that there ought to be an amendment, but the fact that there was no amendment still doesn't change much for him. You don't share that view. In fact, the court, we understand, courts can take judicial notice of things that are, as it were, notorious. And the court took judicial notice of the declaration of vacant seats by the Speaker, even without the plaintiff amending his writ, especially as on the record, the record of the proceedings of that day's sitting was before the court, regardless that we have been told that that was not certified.
Well, that's an evidential matter. Evidential matter arises in the course of hearing a matter you have jurisdiction over, ab initio. Then you can judicially notice notorious facts, but not when the action is non-es. It's non-es. I think, it's too late to contend that a premature suit is a jurisdictional matter, ab initio. And you cannot subsequently plead facts which have happened subsequently to relate back. Because it will involve the doctrine of relation back to the time of the institution of the suit. So you cannot use subsequent facts to relate back to an action that was non-nest ab initio, not a matter of amendment.
Still around the jurisdiction issue, is anything wrong with the court, the majority, relying on depositions in the speaker's affidavit in support of, his application to set aside the stay of execution, which was dismissed? They rely on the affidavit evidence to argue the point of the jurisdictional challenge when they admitted that the speaker did not file a statement of case. If the speaker has not filed a statement of case and this is already on the record in the court, can they rely on it?
Well, I wouldn't fault them for that, because in the course of adjudication, a court is entitled to take notice of all matters that have been adduced or filed before it. That's one of them. And it's even to the speaker's interest that they did that, because he didn't file anything, yet they went fairly to what he had put before them already, relating to the same issue of jurisdiction anyway, to kind of still give him some hearing. I don't see any problem with that. And let me make this clear. Even if a document is void, null and void, it does not preclude the court from using facts contained in it for any purpose.
Okay. Now, having spoken about how premature this, because it was it was a non-ex, and could not be cured by how things have happened. Yeah. There is a part of the judgment, there's a statement at page 14 of the lead decision. I want to read it to you again and find out if you don't share the view that it dislodges your preference for the basis on which the minority dissented and dismissed the suit on jurisdiction. They said that this suit essentially hinges on a pure question of law, specifically the proper construction of Article 97(1) G and H to establish the legal threshold for triggering its provisions without delving into the factual disputes regarding seat vacation in Parliament, which properly lies within the High Court's purview under Article 99 of the Constitution. Accordingly, to the extent that the exclusive preserve to settle a matter of interpretation under Article 2(1) and 131 and 2 lies with the Supreme Court, it is incumbent on this court to exercise jurisdiction and resolve the interpretation for the application of the High Court.
This a novel constitutional interpretation and principle. I'm sorry, I cannot agree with that. To all due respect to them. The cardinal question is not the ratum of the matter that to deal with. Is jurisdictional matter. Jurisdiction, I mean, as like lack of capacity, it's like an axe. When it falls, it falls. That is it. So it's not a question of good intendment. It's a question of existence or non-existence of the jurisdiction. So you don't want to excise one part of a matter relating to a jurisdiction entrusted to another body and start dealing with it. It is the corpus of the subject matter is about vacation of seats in Parliament. That's the corpus. Afenyo Makin didn't go to the Supreme Court simply because Bagwen was interpreting an article, because it affected the vacation of seats. That was the substance of the matter. So you cannot, it's an established principle of the courts that however you camouflage your course of action, which properly should belong to another forum, you'll be be directed to that forum.
You essentially agree with Thaddeus Sore, Kuku Ansan Sare, Kwame Akufu, that the judgment is not accompanied by any orders and therefore, like Kwame Akufu puts it, without teeth and grip.
Well, that is as regards its enforceability. Yes, the Constitution itself, says so. Because Article 2 doesn't stop at declaration. It goes further. Say the Supreme Court shall, for the purposes of a declaration under Clause 1 of this article, make such orders and give such directions as it may consider appropriate for giving effect or enabling effect to be given to the declaration so made. So the Constitution itself is there that the bare declaration to be effective needs further orders. It's quite clear. So if you just stop at a declaration, it has legal force, but the enforceability aspect of it is absent.
Are you saying by this, and this will be my final question to you, are you saying by this that your earlier reference, which we have all heard, to Article 3, Clause 3, on the binding nature of the decision of the court, and you use the same thing to caution the speaker against disobeying the court, you gave the admonition even before the judgment was released. Does anything change now?
Well, at that time, I think you, the media, spelled out my interview jurisdiction. I asked for the circumstances of the suit, and then the order that the Supreme Court made on the application for stay. And I was saying that, and they even said that the Supreme Court did not only order a stay, they said that the MPs affected should be allowed to continue until the determination.
That's right.
These were the facts put before me. And upon that, certainly if that directive was given, was stuck to the stay order, there was an enforceable case in which the directive or order which the speaker should not violate on pain of the sanctions of Article 3. But now, the substantive thing has come. And that interim order has lapsed following the determination of the substantive matter. And the substantive matter stands as a bare declaration. So, it's quite...
All right. Justice William Atugba, thank you very much, Your Lordship, for spending time with us this morning to help explain some of these matters. I'll return shortly. When we come, of course, Inusa Fuseni will have a quick bite, and then Gary is still here in the studio. The minority who said this case should not have come to them at all, Avril Lovelace Johnson and Isifu Umoro Tanko. The part of Isifu Umoro Tanko's decision, which has been quoted and spread around, is this. He says that I am in no doubt that the High Court, by virtue of, let me read just a small portion. When I come, I'll read the rest to you. Let's take a break. We'll be right back. I do not hasten to proclaim that I have apprehended with despair the majority's conclusion in this suit, but I state with utmost deference to the Honorable Chief Justice and the rest of my brethren in the majority that not only do I fundamentally disagree with their conclusion, I, with all due respect, also find the decision an aberration to the established and accepted judicial position of this court, which, with profound respect, I hope in no distant future, the resultant usurpation of the constitutional prerogative of the High Court, incidental to the majority decision, will be reversed. And this paragraph 13 of page 76 and 77 of the judgment, Justice Tanko Amadou, in that statement. And per Avril Lovelace Johnson, she said, I am in no doubt that the High Court, by virtue of Article 99(1), is the exclusive forum clothed with jurisdiction for determining this matter relating to whether or not a seat in Parliament can be deemed vacated. As with all other cases, if the plaintiff's capacity is not questioned or is proved satisfactorily, and during the course of the hearing by the High Court, a need for an interpretation of a constitutional provision arises, then the court would stay proceedings and refer such a question to the Supreme Court, whose decision on the matter would be sent back to the High Court for use in the continued hearing of the matter. The fact that this court is clothed with exclusive jurisdiction under Article 131 of the Constitution, subject to that giving the High Court under Article 33 to deal with all matters relating to the enforcement and interpretation of the Constitution and any allegations that an enactment was made in excess of the powers of Parliament or any authority or person by law under the Constitution, which jurisdiction in any case can be exercised upon a reference from the High Court in appropriate circumstances, does not mean the clear provisions of Article 99(1), which provides the forum for hearing and determining the core issue in this matter, can be ignored. And that's at page 70 per Lovelace Johnson. Let's go to Inus Afuseni. Thanks for joining us, sir. We have very limited time now because we are in the season where particularly the NDC and the NPP, they wish to buy the entire period we'll use for the discussion. So you see the long commercials that have to be played. What do you say that the substantive decision of the majority, is it something you can fault? Are they not right in how they have concluded? Okay, so Inus of Sydney's line, we just lost him, but let's come back to you. I see you are making some notes. You can see that, and I have a lot of comments, that it does appear that the majority decision is not popular.
Well, something. It's not about popularity of a decision that to me is necessary. It's about the decision made by majority, which holds, which binds everybody. Popularity, it is not a political party where a popular candidate should win or the non-popular candidate.
This is what Afenyo Markin says. He says, I don't agree that the decision of the Supreme Court is Brutum Fulmen. I rather think when a matter is declared unconstitutional pursuant to the Supreme Court's authority under Article 2(1) and 131, it simply means the matter was null and void right from the beginning. Okay, Professor Bochi said this, so end of story. However, if there remains a debate on whether in this instant case there were no specific consequential orders, precedent exists on how to proceed. In the Abu Ramadan case, the plaintiff returned to court and consequential orders were given clarifying the earlier decision of the Supreme Court. Afenyo Marking, if he's minded, can follow suit. Oh, so it's not from him. This rather, I think, a view from Obi. What do you say?
Well, Samson, I think that for me, where we are, let's relegate the legalese now to the background a bit. You see, we started this thing, and sometimes lawyers can create confusion and they can put clients in different perspectives. This is a matter of national importance. I will advise at this stage, let's put the law aside. And I said it here before, there has to be this serious engagement, both the minority side, the speaker in leadership should engage. There should be engagement.
Right.
We have few months into elections, few days into elections, and we have few months into the end of the lifetime of the government in this term. So I think that government business must run. Between now to January 7th, it must run. Let's hold this legalese and this court thing, and let's go to the table, have a discussion, negotiate.
I made the same suggestion yesterday on
really?
radio, and there are people who got back to me and say, but who started it? And I'm saying, government business must run, because if you want to follow the extreme legal positions and the partisan positions, the least opportunity when Parliament may sit will be first week of December. Who is going to come to Parliament?
I even think that would not to be an earlier time. I think it would rather be January 7th of next year, because with a banter in court and filing and service and all these things, I think at this stage, everybody must hold his hands. Majority, minority must hold their hands. There should be serious engagement in the room, backdoor discussions to find a solution to this problem. I mean, for me, we should look at
this suit and its determination has not resolved the problem.
Well, to some extent, it has declared the Speaker's decision a nullity. Okay? But then, the question is, where do you move from here? Parliament has to be recalled anyway. Right. And I said it here before, when the Parliament is recalled, and the Speaker keeps quiet, in communicating the decision of Parliament, the decision of the court to the parliamentarians, what happens? It comes and just sits down and say that, well, for me, I cannot decide who's majority and who's minority and just keep quiet. What happens?
Okay.
So
we have a problem with Inus Afuseni, but Dr. Tony Edu, thanks for joining us. With the limited time we have, what do you have to say?
Samson, only one point. Since 1975, the House of Lords in the UK decided that the appropriate means of purposive interpretation is to go to the source of the legislation. The Constitution was forged by Consultative Assembly. The Hansard showing the debate that went on, and therefore the purpose for the provisions in question are clear. What the Supreme Court should have done, if they wanted to adopt a purposive interpretation, was to refer to the Hansard. You don't sit down and use a literal interpretation which will color the purpose.
We have a minute to go. What does the Hansard say?
During the debate, we intended that the interests of the constituents must be protected on the basis of what the MP presented to them. And therefore, if the MP decides to cross carpet, he is automatically out. This was a case that should have gone to the tribunal of fact rather than to interpretation. You see, the effect is that the Supreme Court is steadily and systematically chipping away at Parliament and breaching the principle of separation of powers. Very soon, we will have a situation where the Supreme Court erroneously put itself as supra-constitutional body, and it does not have the right to do that. It is destroying the course of our democracy.
All right, thank you, Dr. Tony Edu. And that's all time will allow us. I still have a bunch of commercials, campaign adverts that the MPP and DC want to play. Have a good afternoon. Thank you all so very much. I'm Samson Ladi Anyanini. This has been Newsfile.